Fani is saying, whoa, you defrauded a federal court. And I'm going to charge you with that here in Georgia, in Fulton County. Wait a minute, you're not a federal prosecutor. Fani, being exposed with her lover stealing money from Georgia, is now ignoring congressional subpoenas. Is she going to indict herself for refusing to follow the law? These guys are just testifying about, one, how valid the subpoena is, and number two, how valid the committee is. So I love it. It's just like they're rubbing her nose in it. Donald Trump and his defense team are celebrating because Fani Willis lost another one. You see, this is Trump's defense attorney, Steve Sadow, who we saw as the pit bull in Georgia back during the disqualification hearing with Fani Willis when she was in big trouble because she was indicting her lover and paying him $700,000. And so they were trying to get Fani off the case, and that is on appeal. This case is kind of in a definite hiatus mode, but they're still fighting. They're still duking this out. And so we're battling against two other counts in this RICO indictment. And what Sadow says is, here's my comment about what happened out of Fulton County and Big Fani's case. Says President Trump and his legal team in Georgia have prevailed once again. The trial court has decided the counts 15 and 27 in the indictment must be quashed and must be dismissed. And this came out in a nice order from Judge Scott McAfee. And you see, this involves two co-defendants that are a part of the RICO case, John Charles Eastman and Sean Micah Tresher Still. Two co-defendants. Trump's name's not on there, but he's just one other co-defendant in this case. And as we're going to see in this opinion, this order is going to be big enough to say the charges that Fani brought are illegal. She doesn't have a basis to bring those charges. Now, order on Trump's motion, we'll just say Trump. Trump is the prime mover, right? Trump is the kingpin. Trump is the mob boss. Trump is the main one. So these are a bunch of other lawyers. So shout out to Eastman and Still, who are filing this on behalf of their clients. Trump's getting the benefit. But this is really the Trump case. I mean, these people are involved because of Trump. So they say defendants seek dismissal of the indictment. This is Trump and the co-defendants based on the Supremacy Clause of the United States Constitution, meaning the feds override the states, which totally stinks, but it's in there. They argue that the indictment is preempted by federal statute. So there's some other U.S. code. Fani is taking some federal right away from the feds, and she can't do that. The feds preempt Big Fani, saying that presidential electors fall outside the state's appointment power and police power. So we're going to ask ourselves, right, if this is going to be a persuasive opinion that might be not binding on the other criminal prosecutions happening elsewhere, like, for example, in Michigan and Arizona and elsewhere, right, where Trump has not been indicted, but they are going after the presidential electors. So is this going to immunize them? Saying that state action, the state is prohibited because the subject of the indictment is inseparably connected to the national government. So she's prosecuting, in other words, federal crimes. Saying that John Eastman, who we have a clip from coming up, also is adopting these motions. Trump looks like they're adopting these motions. And so everybody's kind of adopting these things. Okay, so he's given us the procedural history. Everybody's taking these positions. And here's some procedural background. They say on June 5th, the Court of Appeals sua sponte on their own. So the Court of Appeals just, they were kind of just hanging out like, oh no. They issued a stay of all proceedings saying, all right, this is a big problem. Everything is stopped pending the outcome of the appeal that's been granted for the 9 co-defendants, right? So this was the Big Fani case being on pause. Now, in response to her direct request, the Court of Appeals also granted a stay for Hampton, but these orders did not apply to Eastman and Still, and they do not want a stay. Okay, so Eastman and Still, they're like, no, we're not waiting. Like, we want to keep going. So we'll come back on that. Now, the court heard oral arguments, and after considering the briefing, the court finds that the indictment is not barred entirely. Okay, so it's not a total dismissal of all the charges, but because the court also finds that the decision of the Supreme Court in Ray Loney preempts the state's ability to prosecute perjury and false filings in a federal district court, right? So some of the evidence here was saying that these co-defendants, Eastman and Still, sent in stuff to a federal court. And Fani is saying, whoa, you defrauded a federal court. And I'm going to charge you with that here in Georgia, in Fulton County. Wait a minute. You're not a federal prosecutor, Fani. We know you think you're the biggest Fani in all of Georgia, and exactly you are. But that doesn't make you a federal prosecutor. You're as illegitimate as Jack Smith is. So she brought in federal charges, basically based on federal offenses, the federal government was defrauded. And she's like, well, I'll take care of that. No, you don't have jurisdiction. And so these three counts, 14, 15, and 27, must be quashed. They are now deleted. Bye, Big Fani. Sorry. Now, they're still saying that this indictment is also improper under officer immunity, okay, under presidential and officer immunity. So the defense is saying there may be more here. Like, there may be more basis and more reason for dismissing more charges, saying this order does not even reach these issues, nor does it reach the immunity decision that came down from the Supreme Court, because we've not even fully briefed or argued these. And the oral arguments on this took place a while ago before the immunity decision came down, which was this year. So I say, look, these charges are gone now, but we might come back later and dismiss the rest of them. So here's the basis for the opinion. They say, first of all, the Trump co-defendants first argue that after December 8th, 2020, after that time, any state action related to the presidential election was unconstitutional, and indicted offenses are now preempted because the Electoral Count Act is a federal law, and that details the federal Congress's voting process. And so we're asking ourselves if this is going to be the same argument that we'll see in all these other states. I hope we do. Because election-related litigation remained pending as of that date, the defense contends that only Congress, okay, and not a state prosecutor or a state grand jury, can determine the legal validity of presidential elector slates. So Fani doesn't get to decide what's fraudulent or not. That's not her job. That's Congress's job. That's why we have alternate electors and that process that was already in place. They did it back in 1960 with Kennedy. Georgia law presumes the constitutionality of its statutes, and so we presume that it's valid, and the burden lies with the defense to prove that there is a clear and palpable conflict before this court should declare any law unconstitutional. So you guys got to show it's very clear that there's a conflict here. Now, the constitutionality of a statute may be challenged by the defense in two ways. You can say, well, it's invalid on its face. A facial challenge can be more difficult to challenge because it requires higher standards. Now, although this wasn't discussed in detail, the court views their preemption argument from the defense as a mixed challenge, saying the claim is applied to multiple areas, and let's see some analysis. They say, first of all, because it requires an explicit showing of intent, express preemption, meaning Congress says we are literally preempting you. Here, the Electoral Count Act from Congress, it does not expressly preempt state law, so we can't say it's an express preemption. Is it a conflict preemption? Well, it could be. Let's see what they say. It says it does not contain any indication that a slate of electoral ballots would be free from criminal consequences, so the law does not explain that, and the indictment also does not frustrate the purposes of the ECA. So maybe it doesn't fall into that category as well. So likewise, we don't see any alternative purpose here, and so absent any indication to the contrary, the court finds that the statute and the purpose of the law is to mandate, all right, a congressional process for counting the votes. That's it. It's a process and nothing more. So there's no criminal penalties. There's nothing else in there that it dictates. It's just a congressional process. Got it. So now the defense then argues that by removing any reference to alternate slates of electors, the amendments show that the alternate slates of electors were authorized, all right? So remember, they came back and they passed the Electoral Count Act after 2020. They said Trump made up a bunch of stuff. Mike Pence doesn't have the power. He can't do this thing and this thing and this thing. And we said, well, he actually can. We think he can. We don't know if there's a good, logic to that or good basis for that, but it doesn't say he can't. And it doesn't explicitly say he can, but there's an argument for it. And so what happened is they fixed it afterwards. Now, it may be true that when Congress acts to amend a statute, we presume that the amendment has real effects. But the judge says these amendments also do not imply that the previous version had any requirement, right? It didn't require alternate electors, and it didn't offer immunity to those that did. And so the amendments were made in 2022, over 135 years after the initial passage. And as the Supreme Court has noted, the views of a subsequent Congress form a hazardous basis for inferring the intent of another one, right? Congress is fickle. But still, the defendants raise two hypotheticals that could frustrate this purpose. They say, the defense, Trump and the defendants say that if Congress had hypothetically accepted the slate of ballots that they sent in, if they accepted it, the indictment would interfere with that under the ECA. And the judge says, perhaps, maybe. But this is not the scenario that occurred here. And for the purpose here, the court doesn't have to go into hypotheticals. Now, Congress only accepted and counted the electoral votes certified by Governor Kemp, not the alternate electors. And so second, they also contend that there was a conflict because after the safe harbor date, the determination of valid electors is an exclusively federal issue. And so Georgia and their certified slate of electors was not conclusive under the ECA because there was litigation under effect. And so in this way, they say that the indictment could be seen to frustrate Congress's purpose as well. But the judge says this is not conclusive. All right, look, in short, the function of this is to prescribe Congress's process process of counting the votes. Thus, the court concludes the state's prosecution is not barred by conflict preemption because it does not impair congressional vote counting as prescribed by the ECA. And finally, the court cannot find any support that Congress intended this to preempt the entire state criminal law field about elections, right? It's not a criminal statute, so the state does have some power. So the judge is getting rid of all the stuff that doesn't apply before we get to the stuff that does apply. In summary, the court finds the state's indictment is not preempted, right? The entire indictment is not preempted by the Electoral Count Act because it doesn't expressly preempt state law. It doesn't create an impossibility of compliance. So in other words, you can charge somebody and there can be compliance. The indictment does not obstruct the fulfillment of the purpose and it does not exclusively occupy the relevant field. And so to the extent that they want to dismiss the entire indictment, not going to do it. Now, while the defense may have believed themselves to be acting lawfully under the ECA, the intent cannot be examined right now, and this order does not reach the merits of intentionality at the trial. But then we get into the appointment power. Now, outside the traditional preemption context, they also argue that the indictment of these unelected federal electors lies beyond their grant of power. So it's not about the ECA or supremacy per se. The state can't impede on the appointment power that's in the U.S. Constitution. So the argument relies on another Supreme Court case called U.S. term limits. They explained that this is the rule, that the Constitution says that states get to prescribe the time, place, and manner of elections for members of Congress, as well as the power to appoint presidential electors, delegated powers to the states, while the 10th reserve the rest of them. So any additional exercise of power within that framework must be delegated to the states by the Constitution. And so after consulting these cases, the court concludes this indictment is within the state's power, saying that the state may prosecute a person for fraudulently voting for electors in the Electoral College and so on and so forth. So we're going to keep the entire indictment. But then we're going to get to some inseparable problems. So this is the problem now, ultimately. Now, finally, the defense argues that because the election of the President of the United States is inseparably connected to the functioning of the national government, the Supremacy Clause bars the indictment. They rely on this case, in re Loney, which prohibits state prosecutions for perjury related to statements that a defendant made while testifying in federal court. So the crime was committed in a federal location, in a federal jurisdiction. And so that Supreme Court case says that when a witness is testifying under oath under the federal level, they provide testimony in obedience to the federal laws. Now, similarly, in another case, the Georgia Supreme Court found that a state court did not have jurisdiction to prosecute another defendant for perjury when a crime is committed in the public justice of the United States. So if you're lying to the feds, it's a federal crime, not a state crime. The court in that case based its decision on a federal statute, which says exclusive jurisdiction is in the federal courts for crimes against the United States. And so now they say, after the state safe harbor date, Congress was adjudicating the validity of the presidential electors. So any action, right, Congress was now adjudicating this. So the defendants enacting as presidential electors would be barred from being prosecuted by the state. He says, we're not going to go that far. The majority of the indictment says that you violated state law, but there are 3 counts which say that you're lying to the feds. And so Fani overly charged you on this. So count 27 is going bye-bye. The central holding of Loney is that the power of punishing a witness for lying in a federal judicial proceeding is it stays with the feds. A federal preemption case saying states may not impose their own punishment for perjury in federal courts. So the central holding in Loney is about whether the feds can police their own proceedings. And so yes, they can. At the time of this indictment, federal laws have a mechanism for filing false statements made under oath. So U.S. attorneys could prosecute them for these crimes if they wanted to, but they're not. As a result, Georgia does not have a legitimate interest and jurisdiction to punish these things. And so in the undersigned opinions, the judge is saying Fani's effort doesn't overcome this point. She shouldn't have charged this crime. Decisions from other appellate courts also give us persuasive examples. And so if we apply it to this indictment here, count 27 says that the filing of false documents in violation of Georgia code. But here it is in the Northern District of Georgia. Okay, so she's saying you violated state law, but the fraudulent filing happened in the federal courts. And so it's a federal court. Federal law already exists for this. And so this charge must be quashed. So that one goes bye-bye. Similarly to counts 14 and 15, little different question, but now we're asking dual sovereignty questions. While the conduct under count 27 could be directly punishable by the feds, these charges say that false documents were mailed to the district court in violation of Georgia law. Now, also, they say this lies beyond the narrow holding, so can the state also concurrently prosecute conduct like mail fraud? The doctrine of dual sovereignty holds that both the federal government has concurrent jurisdiction when a crime is against both the state and the feds. And the judge is giving us several examples of this. The reasoning employed by this supports the conclusion. It's essential to the impartial and efficient administration of the tribunals, that witnesses should be able to testify freely before them. So filing a document in federal court is analogous to providing testimony. So counts 14 and 15 here interfere with the district court's ability to do that. They impose a state sanction when a federal sanction is already in place. And so counts 14 and 15 must also be quashed. And so the other counts doesn't extend to the other counts. Now this one, right, because they also delivered stuff to the archivist of the United States, but they say the archivist is not quite enough. False statements to the archivist don't fall under perjury statutes. And so those will remain. And this is basically more Judge McAfee being more Judge McAfee. Overt acts, he says, finally, the quashal of these three counts does not affect the corresponding overt acts. Overt acts alleged can still be in the RICO indictment. And so it's like death by 1,000 cuts. It's like, Judge, this whole thing should have been disposed of a long time ago. It's really just mincing words because Judge McAfee is in the middle of an election. All right, conclusion. The Electoral Count Act does not preempt any of the statutes invoked. The indictment is also within the scope of the state authority. Fani can do whatever she wants, nor is the subject of the indictment so inseparably connected to the national government that it's embarred by the Supremacy Clause. And he's not even addressing immunity yet, right? So this is like a year-old issue without even bringing in immunity into this. This feels very just circular, like we're just wasting our time here. And he's just doing a lot of academic, right? It's academic stuff, which I guess is important in the law. But this case should have been dismissed a long time ago. And Scott McAfee continues to be a little spineless judge there in Georgia. So that's the decision. Now, it is ultimately good news because Eastman has a victory here. John Eastman, you know who he is. He's been all over the place fighting like hell against corrupt interests. And so he was out in the aftermath of this decision. And here's what he said.
Here's what we're talking about. It's a decision from Judge McAfee down in the Fulton County Superior Court that goes strongly against Fani Willis. It dismisses 3 counts, and those are 3 counts that were challenged by John Eastman and a state senator named Still.
That's Jeffrey Clark.
And then
not John Eastman.
President Trump, as you noted, was a party to 2 of those counts. And so he benefited from the fact that they won the dismissal of those counts. President Trump and I and several others are up on appeal to the Georgia Court of Appeals, arguing that Fani Willis needs to be disqualified from this case and that Judge McAfee erred in not disqualifying her. That case is going to be argued in December. But John Eastman and State Senator Sean Still did not join that appeal for whatever reason. And so Judge McAfee issued this decision kind of grinding through their motions, attacking the indictment. And here, let me explain to you what's going on in terms of what got dismissed. So a little bit of, I guess, Clark Law School class for the War Room audience, but it's a sophisticated audience. An area of federal law called preemption, which is based on the Supremacy Clause in the Constitution. And it says that federal law, supersedes conflicting state law or even areas where the federal government occupies it completely.
All right, so that's Jeffrey Clark, and he's going to give us more analysis. We just read through the full opinion, but some good stuff from him. We also know Fani Willis, in addition to losing her case badly, being exposed with her lover stealing money from Georgia, is now ignoring congressional subpoenas. Is she going to indict herself for refusing to follow the law? So she plans to defy the subpoena. She did that today. Fulton County DA is not showing up. She got a pair of subpoenas and she skipped the hearing. Her attorney said she's not showing up. Move is now going to set up a showdown in court where her attorneys have argued that the subpoenas are void because they were improperly issued and they were overbroad. She got a summons. She was supposed to show up there today in front of the Georgia Senate, and she did not. And here is exactly what that sounded like when Fani Willis was flouting the law.
The last person on our agenda, of course, is the first person, Honorable Fani Willis. She has not appeared yet. I would ask the doorman, please check the hall to see if she has appeared before we adjourn.
No, she wasn't there.
Let's please note for the record that Ms. Willis has failed to appear in compliance with the subpoena and has failed to produce documents requested by our subpoena for the production of documents.
Flouting a congressional subpoena from Congress in her local state. Now, here's a little bit more. We'll listen to a little bit of this from the hearing. This is what it sounded like when it got started.
This morning, I will call to order Senate Special Investigative Committee. We have a full agenda this morning. First, we need to approve our minutes from the last minute, and then we have subpoenaed Fani Willis to testify. Here? According to press reports, she is defying her subpoena and not appearing, but we will welcome her if she appears at some point during the meeting. We also will have a presentation by Mr. Stuart Morelli of Legislative Counsel's office. If you look in your folder, you will note that there is a memo that Legislative Counsel prepared back in 2016 dealing with legislative investigation, administering oaths to witnesses, and issuing subpoenas. So we are guided by their work work and their legal advice. So I wanted Mr. Morelli to kind of educate the committee and the public on this process of an investigative committee, as well as our subpoena powers.
No, sir. And I'm going to provide some, information on this case. It is the Trump v. Mazars case out of the United States Supreme Court in the Mazars case. The Supreme Court did provide that Congress has no enumerated constitutional power to conduct investigations or issue subpoenas, but we have held that each house has the power to secure needed information in order to legislate. And they cited to a 1927 opinion of theirs, McGrain v. Dougherty. The Mazar court went on to provide the power of inquiry with process to enforce it is essential and appropriate auxiliary to the legislative function. Again, citing back to their 1927.
So they've got the power to subpoena Big Fanny, is what he's saying.
And went on again to state, without information, Congress would be shooting in the dark, unable to legislate wisely and efficiently.
Where you at, Fanny?
As I said, in 2020, the Supreme Court was citing back to its 1927 precedent, upholding Congress's power. State Supreme Courts have held the inherent power of their legislatures to conduct investigations, going, I believe, as far back as 1824, when the Massachusetts Supreme Court, I believe, was the first state Supreme Court to address the matter. As I said, it has been a near universal finding that legislatures have this authority. The only dissenting view that I'm aware of was stated by Justice Thomas in the Mazars case. He did believe that the precedent relied upon by the Supreme Court and the other state Supreme Courts was misguided.
No, Fanny.
No other justices joined in that opinion. Other state Supreme Courts have continued subsequent to the issuance of Mazars to continue to also uphold state legislative investigative powers of their legislature.
All right, so she should be there. Let's see if we get some other questions.
And as far as you're concerned, does that constitutional provision also apply to investigative authorities as set forth by Senate resolution? Make sure I remember the number here. We have this in the folders as well, 465.
I see no reason why that provision would not apply to a standing or a special committee as well.
Fanny should be there. There's more.
My hands on the Senate journals for the 1965 session, so I do not know what the report said. The 1964 resolution creating the interim committee to investigate Stone Mountain Memorial.
Okay, so even more. So they're laying a ton of foundation here, a lot, that saying Fanny should be there. Okay, we got all this precedent. Supreme Court has said it. Georgia has said it.
That courts, when considering legislative subpoenas, in certain cases, in Mazar's case, the president, need to show some heightened concerns to recognize the separation of powers. I was being a bad attorney and not giving you the cites.
You got a whole bunch of attorneys on here. You got a couple of non-attorneys that are as smart as her.
And I can provide copies of any and all of these cases to any members who wish them. The citation for Dean versus Bolton is 235 Georgia 544. And again, it was a 1975 case.
Where's Fanny?
Yes, sir.
So even if it's not specified verbatim in our Constitution, our courts have followed the United States Supreme Court interpretations. That
is this whole hearing going to be about why Fanny is violating a subpoena? I love it.
28, which were subsequently added much more, I think in, the early 2020s, the detailed ethics provisions that give a second independent statutory procedure.
This is now a hearing about how subpoenas work in Georgia. I love it. The whole hearing.
Mr. Leader.
This will be short. Stuart, thanks for being here today. It's great to see you this summer. OCGA 55, 15, 17, and 19. When were they adopted into law and by which governor was it signed?
I don't know which governor. They were initially enacted into law I do have that before me if you will give me a second.
Okay, we have another guy who's going to come testify. So let's see who this guy is.
And tell us what you're doing now in retirement.
I wish I could get to retirement. I'm almost there.
All right, so I think it's a hearing about subpoenas.
In each house and may be exercised through a committee. That's Mason's 795-11. So the creation of the committee, I think, was done in accordance with statute, in accordance with rules, but it was also done in accordance with our precedents. And Stuart touched on.
Okay, this is hilarious. So Fanny didn't show up. So their other witnesses are just people to say, these guys are just testifying about one, how valid the subpoena is, and number two, how valid the committee is. So I love it. It's just like they're rubbing her nose in it. And they're doing it like total gentlemen. They're just kind of hanging out, just chatting.
What the Senate's powers are, not as restrictive of it.
So they're pre-butting Fanny's objections. They're just doing it in public. She's saying this is overbroad. This committee's illegitimate. You have no subpoena power. The whole hearing
on this
is just about how they do have the power.
Counsel on anything that I might have said from a legal perspective.
All right, let's see how it wraps up.
Under the attorney-client privilege, our rules do permit, I think it's Rule 5 of our committee rules, that we can go into an executive session or a session that is closed to the public. So that requires a majority vote of the committee. If anybody is interested in having a private conversation with our counsel to let us know where the litigation stands, now would be the appropriate time to move.
Hold her in contempt
for that. I recognize
for not being
Senator
there.
Kennedy.
Thank you, Mr. Chairman, for that. And I would move that we do, pursuant to Senate Rule 1-5.1, as you just stated, have this committee move to go into executive session for the purposes of hearing from appointed counsel to advise us.
Is there a second? All right, we have a second. Any discussion by committee members on the appropriateness of that or the desirability to have a private briefing? All right, all in favor of the motion, say aye.
Aye.
Any opposed? One opposed. All right, that time then we will conclude the public portion of this meeting and we will stand adjourned. As a public meeting, we will continue in a executive session to be briefed by our counsel on the current status of litigation concerning the enforcement of the subpoena. Thank you. We're adjourned.
All right, so that's the hearing. So interesting. It was an interesting one, actually. It was very kind of in Fani's face. Okay, here you go. Oh, you don't want to show up and be here? Well, we'll just talk about how wrong you are for a full couple hours with some very qualified people to do that. So we're going to be here to continue to cover this one, my friends. Thank you for joining. Thank you for subscribing. Thanks for liking this video. We would love to see you back here on the next one, and we'll see you back here when we do.